Too often, lawyers think succession planning is primarily about finding the right successor. While doing so certainly is a central component of your planning process, addressing the insurance coverage concerns both before and after a transition is an additional task that should never be overlooked. Fortunately, it's a rather simple process, so let's break it down. First, the pre-transition concerns. While you're still actively practicing, make sure that 1. Your malpractice policy is always current and in good standing, because an unpaid premium or lapsed policy could create a coverage gap, which can also result in the complete loss of prior act's coverage. 2. Your current malpractice policy limits are high enough to cover your exposure post-transition, because you can't raise your limits when purchasing a tail. The reason is a tail is an endorsement that only extends the time a claim may be reported after your final policy has expired or been canceled. It provides no additional coverage and is not a separate and distinct policy. 3. In the event of an unexpected event, you have sufficient funds available to cover the cost of purchasing a tail, which, if you don't happen to qualify for a free tail, can be as high as 300% of your final policy's premium, depending upon the desired duration of the tail. And 4, you consider purchasing key person insurance, a term life policy, and/or disability insurance, because these tools can help provide critical financial support for paying expenses during a wind-down process and providing financial protection for you and your family. Now, let's talk about post-transition concerns, specifically those that will need to be addressed by your successor attorney. 1. Since the window of opportunity to purchase a tail is limited, make sure this person knows how to contact your malpractice insurer, who to contact, and how long they have to accomplish the task of notifying your insurer of the transition and purchasing a tail. And 2, since the process of winding down a practice doesn't happen overnight, your firm's computer network will remain active for a period of time. As with your malpractice insurer, make sure your successor also knows how to contact your cyber liability insurer and who to contact so that notice of the transition can be given and to request tail coverage be put in place for at least the following year. Here again, make sure sufficient funds are available to cover this expense. Here's the bottom line. Your succession plan isn't complete if you fail to address the insurance concerns that are present both before and after a transition. In short, make sure your policies are current and readily accessible. Your limits are adequate and your successor is fully informed. This is how you can make sure that you and your clients are fully protected post-retirement, death, or disability.